Judge, that's my motion for contempt. I believe the contempt is going to be stipulated to. We can pass that for some oral arguments on what the.
So do you want to do it on the second call, or are you wanting to do something about it today?
I have two officers here today that if we're going to stipulate to the contempt, I can let those guys go. If we're going to stipulate to the contempt, and we'll put some oral argument in front of the court as to what to do for the.
My question is, do you want me to pass it on the docket to let you and your opposing counsel talk about this?
We do, as long as we've got the contempt stipulated to, and I can let the officers go. That was one of the things I was trying to get those guys out.
So in answer to my question, do you want me to pass it on the docket today to let you and Mr. Barnhill talk about the case, decide whether or not you want to let these officers go by stipulating contempt, and then we'll come back to it?
No, Your Honor, we're ready to do that now.
Ready to do what?
Stipulate.
All right. So are you ready for a hearing then after the stipulation of contempt?
If we're going to have to do that for the sentencing, yes, sir. We may talk about that a little bit, see what we can do.
Well, we'll put it on the second call and come back to you as soon as you two can figure out what you're going to do next. So,
Yes,
but as far as the stipulation of contempt, it's my understanding, Mr. Barnhill, this is a stipulation that your client is in contempt of court.
Yes, Your Honor.
And is this a civil contempt that was
This is a
sold?
criminal contempt, Your Honor.
It's a criminal contempt. The court heard a motion about 2 weeks ago. They recall a restraining order about the apartment. Officer Moss testified about the conditions of the apartment. You made some rulings with her. At that time, I hadn't had time to set the contempt, so it was set for today separately.
Yes, Your Honor. I believe that the court heard enough testimony last 2 weeks ago, and I don't think that there's any need to rehash everything, Your Honor.
Well, what you and your client feel and what the plaintiff feels are sometimes two different things. Mr. Gervin, I want to make sure that you understand your rights. So raise your right hand. Let's place you under oath.
Yes, I do.
That's your full name for the record.
Robert Allen Gervin.
Mr. Gervin, you are here today charged with criminal contempt, and I want to make sure that you understand what is the significance of that is. Do you understand that you are charged with violation of the court order and that violation is alleged to be criminal contempt? And if you are found guilty of criminal contempt, you are facing a possible sentence in jail of 10 days for each and every violation of that order. Do you understand that?
Yes, Your Honor.
You understand that you have a right to plead not guilty to this charge and to have a hearing in this court where I'm going back to my criminal docket call, where the plaintiff would be required to prove beyond a reasonable doubt that you have violated the court's orders and in a criminal fashion.
Yes, Your Honor.
You understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case in the way of imposition of sentence to the Court of Criminal Appeals,
Yes.
or to the Court of Civil Appeals, actually, in this case.
Yes, Your
You
Honor.
understand that by entering a plea stipulating that you're in contempt of court, you're admitting that you're violating the court, and all we'll do is move to a sentencing and whatever the appropriate sentence would be.
Yes, I
You
understand.
understand all of these rights?
Yes, Your
We
Honor.
talked this over with Mr. Barnhill.
Yes, Your Honor.
You believe that you and he have discussed it fully and that you understand what you're doing.
Yes, Your Honor.
Do you wish to waive your right to contest the issue of your contempt and enter a plea stipulating that you're in contempt of the court's orders?
Yes, Your Honor.
All right. Then we'll move to sentencing. Have a seat. Holly, you wish to make an opening statement?
Judge, contempt's already been stipulated to. There's a hearing again that was 2 weeks ago. I'm sure the court's familiar with all the evidence that was put forth at that motion. Mr. Barnhill was not here. If you recall, he was sick and he had someone standing in for him. That being said, I mean, he's pled guilty to the contempt, and it was no questions asked. I mean, the officers came over and this minor child was in the apartment with John Gervin with a specific order down that says he was not supposed to be there. And wasn't supposed to be around the child at all. So we're asking that it be 1 contempt and 10 days of incarceration. If he still has his job, we have no issue with that being weekends or some time that doesn't affect his job or some period of time that doesn't affect his job. But this case has been going on for some time with the issues that we've had, and the court can look at the file until it's fairly thick. I think at this point we're okay to ask for 10 days of incarceration, and I think it would be necessary for him to understand the gravity of that situation. I think the court can remember back to the hearing. I don't think he really understood the gravity of the no contact order. Tried to get into that some, and the court made it pretty aware to me that, you know, it wasn't a question of why that order was down. It was a question that order was down and whether or not he violated that order. Thank you.
Barnhill, do you wish to make an opening statement?
Your Honor, obviously, my client is aware and does understand the situation here. We just discussed that with Your Honor when you asked him, if he understood what he was agreeing to do when we stipulated the contempt. Your Honor, while this matter has been going on a while and it is a rather thick file, the issues that have come up have not been with non-compliance with orders. This is not a frequent occurrence. This is not something that has been brought to the court's attention multiple times. Instead, we have here, and what Your Honor stated at the last hearing was that we have a situation where a man has been dealt a very difficult hand, and the ways that he has dealt with it have by no means been perfect. But we have a situation here where my client is trying everything he can to be the best father he can for his daughter. Sentencing him to serve 10 days in jail serves no one here, Your Honor. It would restrict any time he would have with his daughter, which the court found at the last hearing. Not only is he a loving father, his daughter loves him very much, and the court stated repeatedly that it's important that he be around his daughter. Sentencing him to serve weekends would take that away from him. It would also restrict his ability to earn money. I know that his ability to pay child support has been an issue before. There was a motion for contempt on child support. He's now up to date, so that was made moot. But sentencing him would restrict his ability to earn, which would further hurt his daughter. Your Honor, I believe that it is in the best interest of the child in this situation that he not be sentenced to serve time.
Mr. Hawley, you may call your first witness.
Judge. I'll call Ms. Tressler. Ms. Tressler, you've had an opportunity to testify at the last hearing, correct?
Correct.
And you've had an opportunity to hear the statements made today by myself and by opposing counsel, correct?
Correct.
And you heard the statement made by opposing counsel that this was a unique type of event, that this was not something that, was experienced on a day-to-day basis. What do you say to that?
I disagree.
Explain that to the court.
As far as what we're here for today with the brother, he's been around multiple times.
Object, Your Honor, that this is outside the scope of the contempt hearing. In the criminal contempt motion, there's one allegation, and that's all that we're here to discuss today, Your Honor, is that one allegation of criminal contempt, and any discussion of anything else is outside the scope of this hearing. Because it was not my client was not properly put on notice in line with the rules for criminal contempt that anything else would be discussed.
May I respond? It was his statement. I'm asking her to respond to his argument. Counsel got up here and said exactly
The
what he
issue's
said.
been raised by counsel argument, and I will overrule the objection. It is for sentencing, and therefore rules for sentencing are a little more lax than they are for an evidentiary hearing on the question of whether someone is or is not guilty. So overrule the objection.
So you can answer the question and get into some detail about what you've experienced in the past. And again, not with everything, just with John Garvin being around your daughter, that you know of.
The order was in place for him to not be around, and he was continually around. Even recently, we dropped her off on Sunday. Brother was there. Brother did state that he was leaving and put his shoes on to supposedly go to work. But when I arrived to pick Elena up, the car of the brother was still in the parking lot. And Elena said that she sat in the car to wait for her dad to, go upstairs and try to make the brother leave.
And this was when? Just to be clear.
Sunday.
And this was after the last hearing?
Not this Sunday. Yes, it was last Sunday.
This was after the last hearing.
Yes.
And did you, like the judge ordered, did you go up to the apartment, kind of look in a little bit and back
Yes,
out?
I did. And it was cleaner. They had shown progress of getting it cleaned up. And the reason we chose to leave Elena was because brother was putting his shoes on and said he was leaving to go to work.
And you took that for what it was worth? And
I took their word in good faith that brother would leave to go to work.
And once again, this was even after that last hearing.
Yes.
So you understand why we're here today. He stipulated to the contempt, and we're requesting that he do 10 days of incarceration.
Correct.
And you agree with my statement that you don't have any issue with him arranging the time so that it doesn't affect his job or even his visitation?
Correct.
Why do you feel like it's important that Mr. Gervin at this point receive some incarceration for what he's done?
So he can understand the extent of the situation. Don't want him not to be around his daughter. They do have fun when they're together, but under the circumstances of the brother, I'm just not comfortable with her being around, and I don't think he understands the extent of that just yet.
And what has Mr. Gervin said to you about the issues with his brother and being around your daughter? Has he ever expressed any concern to you about that?
Yes, there has been times throughout that he has had concern of his brother's state of mind, especially if he is not taking his medication like he needs to.
And the fact that this is in an order of no contact, we had actually come to an agreement on that, correct?
Yes, we did. We came to an agreement that the brother would not be around Elena.
And that was your request, and Mr. Gervin had agreed to that, correct?
Correct.
That's all I have.
Mr. Barnhill, do you have a question?
Yes, Your Honor.
Concerning this, 2 weekends ago, you said that you dropped off your daughter and John was the brother. John was putting on his shoes and he said he was going to work. Okay. You decided to go ahead and believed them and you left your daughter there?
Correct.
Okay. And then you said you came back and his car was in the parking lot and that, what was it, your daughter said that she had to wait in the car? Could you explain that a little bit more? I'm not quite sure I understood what it was that happened.
Before I even went to pick my daughter up, I received picture evidence that his brother's vehicle was in the parking lot.
From who?
A friend.
Okay. Who is this friend?
Her name is Robin. She
Robin.
lives in the apartment complex.
Okay. So she sent you a photo of the car being there.
Correct.
Okay.
And asked me if Elena was with her father today.
Okay. And when you showed up to pick up your daughter, was John there?
I did not see him. I was not granted access into the apartment, so I don't know. It did kind of rub me a little weird because when I got there that morning, there was no problem with me walking into the apartment. And, you know, he was putting his shoes on, supposedly leaving for work. But then when I got there and knocked on the door, it was being blocked by the door and I'll get her. And then, like I said, the car was in the parking lot.
Mm-hmm.
And on the way home, I asked Elena,
Mm-hmm.
what'd y'all do today? You know, did you have fun? And she said yes. And, you know, I just simply asked her the question, well, was your uncle there? And she told me that she had to sit in the car because Dad had to go up and ask him to leave because he was there.
Okay, but your daughter wasn't around him then?
As far as I'm aware, no.
Okay, so as far as you know, Robert was in complete compliance with the court's orders.
I would like to hope so, yes.
Okay. You also stated that in the past, Robert had talked to you about concerns about his brother's behavior and mental health.
Mhm.
You know, specifically when his medication was off or something like that. Did he ever explicitly state that he felt that Elena was in any danger or that John posed any threat to Elena?
Honestly, I cannot remember. I mean, it's
Okay.
been multiple times that we've talked. It's been,
Okay.
you know, it's been years since we were together.
Okay.
But there's always been concern of his brother.
Okay. Okay. So those concerns, when you guys had those conversations, they were far enough, they were distant enough in the past that you can't remember the specifics. So
Correct.
he hasn't expressed concerns recently then? There's been no express of concerns recently?
Well, he agreed with me that she didn't need to be around him
Well, I think the fact that
unsupervised. So
when you say agreed with you that she didn't need to be around him unsupervised, you mean he agreed to the order?
yes.
Okay. Okay. But he did not express any statement to you that the order was necessary?
Not that I can think of at the moment, no.
Okay. All right. Nothing further, Your Honor.
Redirect, Mr. Holly.
Are you familiar with fact that John and Robert had gotten into a fight in 2022 during the
Yes.
process?
Your Honor, I think this is outside the
Yes.
scope of redirect.
He kept asking about, the issues with whether or not she felt like there were any problems at all with, John being around and any recent type problems.
Prior testimony, the proof was that there was some issue regarding the brother that caused both of them to be concerned, and that's why the agreed order was down. Beyond that, doesn't really matter. We have an agreed order that is enforceable by this court, and this is the sentencing for contempt. The reasons why they entered into that order are not necessarily before the court, because there's no motion to relieve or to change that order. So that becomes irrelevant as to what the reasons were and so forth.
Yes.
I recall what the testimony was at the prior hearing as to the reasons why, and we just have, it's already been established that there was a court order down that he agreed to. He did not abide by that court order, and so the question becomes, what do I do about it?
Yes, sir. No further questions.
Thank you, Mr. Do you have anything else, Mr. Barnhill, for this witness?
No, Your Honor.
Step down, Mr. Trustee.
Yes, sir.
And your brother is John Garvin,
Yes, sir.
and you do understand why you're here today. You pled guilty to contempt.
Yes, sir.
And from the facts that were in the contempt petition, you've agreed to those for the most part and pled guilty. Do you understand that?
Yes.
All right. So you testified last time that you were working at Midas.
Yes.
Are you still working at Midas?
No.
Why are you not working at Midas any longer?
I'm having trouble remembering.
Yeah. And, you testified last time that you were seeking veteran benefits for some of your issues, correct?
Yes.
And were you honorably or dishonorably discharged?
Honorably.
Okay, so you weren't dishonorably discharged for
No.
AWOL?
No.
Good. Your situation with your brother, it's volatile at your apartment, correct?
Your Honor, I'm going to object to relevance basically to all of this. I mean, you've just stated that essentially the order was in, it was violated, we're here for sentencing. I don't know that the discussion is relevant to this, what we're deciding right now.
What is the relevance, Mr. Holly?
I'll move on, Judge, if it's not relevant.
Stand the objection.
All right. Are you working anywhere now?
I'm currently looking for a new job, but I do Instacart and DoorDash whenever I have time.
What else would you be doing with your time other than the visits that you got with your daughter?
That's it.
Okay.
I go to work and then I come home, go to sleep, get up, go to work, and then I have days with my kid.
But sitting here today, you can't remember, if I heard you right, you can't remember why you don't have your job with Midas any longer?
I think they were looking for somebody who was more experienced than I was, but that's my belief. You'd have to ask them why they fired me.
Huh? Is John Garvin, is he still living at your apartment?
Yes.
Is he still allowed to be around you?
No. Well, he's not allowed to be around Elena.
Okay. Were the bond conditions from the episode in August lifted where he can be around you?
What are you talking about?
Do you remember you and Mr. Garvin, John Garvin, got into a fight and the police were called and there were some bond conditions?
Your Honor, same objection to Mr. Relevance. I mean, this,
Nothing further.
Mr. Barnhill, do you have a question?
Mr. Gerben, do you understand what a court order means?
Somewhat.
Okay, you understand that if something's put in a court order that you are or are not to do something, that's not optional?
Yes.
Okay, and you understand that you have to follow the orders of this and any other court as it pertains to your behavior?
Yes.
Okay, and obviously here, you've already stated to the court that you did violate this court's order, correct?
Yes.
Okay. Do you have anything that you would like to say to the court as it pertains to that violation and what we're here today for and your perspective on this court's orders moving forward?
There's a lot of things I'd like to say, but it doesn't seem like anybody's going to listen.
Okay, well, we're listening right now. So if you want to say anything specifically about your actions and how you're going to act moving forward, now's the time.
I want John, my brother, he will not see my daughter. He can't.
Okay. So he has not been around your daughter at all since the last hearing.
No. And the only reason why he was there the morning that they showed up on Sunday was because I never got any text and I didn't know exactly what time they were going to be there. I was still asleep when they showed up.
Okay. And when they showed up, John left?
He left.
Okay. And he was not around her, Elena, while you had her?
No.
Okay. Nothing further, Your Honor.
Redirect, Mr. Hawley.
I don't have anything, Judge.
Mr. Garvin, I want to make sure you understand, and I went over this with you before, but I want to make sure you understand it again. You understand that my job is to enforce a court order, and you understand that this order was something you agreed to through your lawyer. In other words, I didn't have a hearing and I decided that your brother shouldn't be around your child. You and and the mother of this child agreed through your lawyers to that provision, that he would not have any contact. It actually says absolutely no contact. It says it is further ordered, judged, and decreed that the minor child shall have absolutely no contact with John Gervin, the brother of the father. And you understand that? Did you understand it at the time?
It was a difficult decision for me to make at the time when I signed that order.
But you agreed to it at that time.
At that time, yes.
And you knew that that was going to be a court order that was going to be enforceable, I assume.
Yes.
Just like all the rest of the provisions of that order, which were how often you got to see your daughter and everything else, right?
Yes.
Let's say I just decided that Ms. Tressel just decided she was going to stop you from seeing your child without a court order, without having anything to do with a court hearing. She just says you can't see her anymore, period. Would that be a violation of the court order?
If it was in the court, yes.
Yeah, I mean, if the court order says you get to see your daughter, it does, right? That agreed order. What if she just told you I'm not doing it anymore?
It would be the same situation I'm in.
What do you think should be done about it in that case? You think she would deserve some sort of punishment for not letting you see your daughter?
No.
You wouldn't think she would, so she would be basically free to disregard an order and no punishment would apply. Is that what you're telling me?
In a way, yeah. If my daughter wants to be around her, I'm not going to stop my daughter from being around her mom. I can't.
Well, now let's turn that around. If your daughter wants to be around your brother, there's a court order that says she can't. Are you going to stop her from being around your brother with this court order?
It's a tricky situation. I mean, I understand what
It's not tricky for me.
Yeah.
It's written here in black and white, and unfortunately, I understand your situation. You got a brother who needs help, and you're trying to help him, and you're letting him live in your apartment. Do you remember 2 weeks ago or whenever it was we had the hearing, and I told you you're going to have to choose between whether or not you're going to put your daughter's focus first, or your son or your brother's focus first? Your brother's an adult, right?
Yes.
So he could find another place to live if he needed to, right?
He should be able to. I would hope so. But everywhere it doesn't.
And do you understand that if you continue to violate a court order, you may not get to see your daughter at all?
Yes.
And you're still willing to take a chance on whether or not you're going to let your brother have a contact with your daughter?
No, he won't.
Well, I want you to understand, I take no pleasure in putting people in jail, but sometimes that's the only remedy I have to try to make sure people understand the significance of a court order they agreed to. Do you understand that now?
Yes.
All right, step down. I don't need any argument in this case. By law, in a criminal case, a first offender, someone who has no prior criminal record, and it's the first time that they've offended, and charged with that offense and convicted of that offense, they would be eligible for probation. A court order is a court order. You agreed to it, Mr. Gervin. You cannot, in this situation, simply say, well, I agreed to it, but I had issues about it, so I'm not going to worry about it and let my brother around. The testimony that was at the last hearing was that you had your brother there in the apartment with your daughter when the police arrived for this welfare check. And you've now admitted to that. So I find that you are guilty as you've admitted to your guilt for violation of the court's order. And I sentence you to 10 days in the county jail, but I'm going to suspend that. And the reason I'm going to suspend that is because it is the first time that you violated a court order. But every time, every day that you violate a court order, every instance, if you violate a court order 5 times in one day, you'll get 50 days. You see to your left, that lady that's sitting there in the pink. When I was practicing law, she had a woman that was violating a court order, and the judge gave her 60 days in jail, 10 days for 6 different violations in a domestic case she'd never been in, and she was a former Army, I think an Army nurse who had never served a day in jail, and that lady went to jail for 60 days. I tried to get the judge to change his mind. You know what he told me? 60 days. So what I want you to understand is that you may have a military background. You may have many things going on in your life that will concern you about what you should do. You have got to put your daughter first, and the first thing you need to do is abide by these court orders. If you don't like that provision, your lawyer, Mr. Barnhill, knows how to change that. You file a motion to alter or amend that order, have an evidentiary hearing where evidence is presented to a judge that will explain why that is no longer an appropriate provision. Then the judge makes a decision. You're bound by that decision. She'll be bound by that decision. So what I want you to understand is when you agreed to that provision and that order, it became binding upon you and binding upon her. She can't ignore what those orders are by saying that she's not going to let you see your daughter. And if she did that, she'd be facing 10 days in jail for every contempt that she violated. But she hasn't done that. So I disagree that making you serve 10 days in jail at this moment is the best thing for you or your daughter. But what I want you to understand is, I don't know that you ever read any history or any literature or anything. There's a famous piece of literature where it's described that God is holding people by a single thread over the bowels of hell. Well, we'll just put it in this term. You're being suspended over the bowels of the Dixon County Jail by a single strand, and that's that suspended sentence. And if you violate it one more time, you're going to serve 10 days in jail. And no ifs or nons about it. You understand that? I don't want you to serve that 10 days in jail. I want you to learn. But if you violate this court order, there is nothing that you can say or do that will make me decide not to put you in jail. So it's just that simple. I want to do it, and if it happens, it will be your fault, not mine. It will not be Ms. Tressler's fault. It will be your fault. So shoulder that responsibility and make sure it doesn't happen. Do whatever you have to do to make sure your brother is not around until you can have a hearing before a judge, if that's what you want to do, to change the order. It's just that simple. But you cannot ignore a court order. A valid court order is enforceable, and I'm enforcing. Do you understand this?
Yes, Your Honor.
And not only will you have 10 days in jail for this offense, if you violate the court order, as I say, you'll get additional 10 days for every time you violate it. So don't put yourself in that position. Don't put your daughter in a position of having to tell her mom that your brother's been there, and then you go to jail. How do you think that's going to make your daughter feel? So think about these things before you take the next step. I see no reason to make him serve a first offense violation of a court order, but I think I've enforced that sufficiently that he understands if it happens one more time, he will go to jail for that 10 days and any additional 10 days the court seems to be appropriate. That's the judgment of the court. We'll put an order down, Mr. Hawley.
I will.
Thank you, Judge. Thank you, Your Honor.